Welcome back to Winning Isn't Easy. Guardian's untimely production of new evidence which was used to deny a claim, is overturned by a court. Now, we have been talking about the games that disability carriers or plans play in coming up with a reason to deny or terminate benefits. Under the ERISA regulations, the carrier has to provide you with a full and fair review of any claim denial or termination. And that includes supplying with you any new evidence that's considered, relied upon, or generated in connection with the claim in advance of the final decision to allow you to respond. Now, what I see is that many carriers use delay tactics. They'll send new reports at the last possible moment. They'll make it impossible for you to respond before a decision is issued. So they'll create all these reasons to deny or terminate benefits. You file an appeal. You've got 180 days to do so. They've got two 45-day periods in which to consider the denial, and they have to ask for the second extension. But what they'll do is they'll creep up to that first 45-day deadline and say, oh, wait a second, we've got some new information here for you to respond to. And by the way, don't you want an extension, to give us an extension so that you can submit more information and then we can consider it? Those are the kinds of games that courts really frown upon. So let me tell you the story of Sammy versus Guardian Life. It's a case out of the Southern District of Florida. And in this particular case, Sammy's benefits were terminated and he appealed. In response, Guardian got two new medical reports and a vocational report addressing the transferable skills. And they gave that to Sammy with the reports the same day they denied his claim, attempting to justify their actions by claiming that they provided the reports as soon as possible and arguing that Sammy had objected to their request for an extension, implying that he couldn't have it both ways. Now, what they also argued is, look, that failure to provide timely evidence is just no big deal. These are common excuses that we hear all the time in the ERISA world. So what did the federal judge do? Well, fortunately, the judge said, nuts to you guys. The judge rejected Guardian's excuses, ruling that ERISA regulations require that new evidence be provided sufficiently in advance, not on the day of the denial. It was Guardian's responsibility, not Sammy's, to ensure a full and fair review within the prescribed period of time. And Guardian's claim that the late evidence was insignificant was absurd because that was the basis of the denial. The judge found that the record was incomplete and refused to rule on the correctness of the termination, instead remanding the case back to Guardian to do what they should have done. Now, I don't like that. I like the idea that the judge recognized that they were playing games. The judge should have said, too bad, so sad, you screwed up, I'm awarding benefits. But what the judge did is he gave Guardian a second chance to justify the benefit terminations. Games that they play are recognized by the court. Hopefully, some of these courts will understand that that's just it. It's a game, and they are hoping that the court gives them, well, one, that you go away, and if you don't, that the court gives them a second bite at getting it right. I don't think that's right. Do you? Now, please, don't let disability carriers or plans manipulate ERISA regulations. You should be fighting back with an experienced attorney. Thank you for tuning in to this week's episode of Winning Isn't Easy. If you found this episode helpful, please take a moment to like our page, leave a review, share it with your family and friends, and subscribe to this podcast so you'll be notified when our next episode comes out. And by the way, I'd love to hear from you. At the beginning of each episode description, you're going to find a link where you can send us your questions or comments. I might even feature them in a future episode. So please join us next week for another insightful episode of Winning Isn't Easy. Thanks.